Welcome to Cut to Legal.
Hey there, and welcome to Cut to Legal with James Pacitti. James is the managing attorney at Pacitti Law Firm, where he helps producers, production companies, and creators protect their projects through every stage of development, finance, production, and distribution. I'm Kevin Rosenquist, and today we're talking about film financing, from investors to contracts, and how to avoid expensive mistakes when raising money for your project. Welcome back, James.
Thank you, Kevin. Glad to be back.
So let's start with just how these films are financed. What are the most common methods of financing for independent film and TV projects?
Well, generally, the most common methods are equity or debt or debt. There are also, you can have pre-sale agreements, you can have gap financing, tax incentives. So those often work into it. Financing for independent films is often kind of like a Frankenstein's monster of parts. You can start out with some debt, and then they get some equity, and then you get different kinds of debt. They bridge loans or mezzanine financing, which gets you to the next stage. And then even after, the film can also then pre-sell. What that is, that territories are sold before the film's actually shot. So you get some money that you can borrow against. You get some contracts that you can borrow against. And so it's often a hodgepodge of different things. Debt and equity is the most common, but within debt, there is different kinds of debt. And then, like I said, in addition, there's the gap, the pre-sales. You can also have tax incentives and tax credits that are available in a lot of jurisdictions.
So when it comes to investing, obviously that's probably something you help producers with, the agreements and whatnot. What do they need to make sure they consider in that agreement to protect themselves?
That's a good question, Kevin. So what should producers be looking for in agreements and finance agreements for their signing? There's a number of crucial terms. Of course, they got to be clear about what the investment terms are and the amount. And what I mean by that is, if they're taking, let's say, equity, and what are they promising to this investor? So what often happens, if someone is putting an equity investment in independent film, for example, they will get anywhere to 110 to 120% back, the investor will, of their investment, plus a percentage of net profits. So an example, if it's 120% and they put in $1 million, they're supposed to get $1.2 million back. And usually that's before any profit share. So that's, you got to be clear what you're promising your investors. You also have to be really clear about the waterfall. And what the waterfall is, that basically is it shows who gets paid first. And that is really important. That is clear, because everyone's happy and excited and chummy usually when you're doing the financing and excited about making this movie. But then when it comes to distribution and distribution revenue, everyone wants to get paid. Mm-hmm. So it's really important that it's clear to the producers, so that it's clear to the investors, what is the recoupment waterfall? Because you have customer off the tops, which is that distributors' expenses, distributor fees, agent fees, residuals for unions if it's a union project, and then debt will often get paid. And then it starts working its way to equity. And so it's really important for that to be clear, because otherwise then no one's really certain when they're getting paid. So that's obviously a crucial element. We have profit participation. It has to be clear about what's the share of profits. It is often 50-50 between producer pool and investor pool, but that depends. Every deal is different. So it has to be really clear what profits is the investor sharing from. Then you have a lot of other various terms, which includes things like creative control. Typically speaking, the investors don't have any creative control, but that should be clear, because that if they think they do, that could be a source of conflict. And then things like representations and warranties. When you're talking about investing, and this gets complicated because we start implicating state and federal securities laws, but typically you want your investors to be accredited investors, and you want them to make various representations or warranties about their ability to invest in the film. And then you should have clarity about dispute resolution, expenses and accounting, and in the case of equity investment, securities law compliance.
And then when it comes to a financing deal, is there, I mean, like, it's different than financing your car, I'd imagine. Like, what are some of the red flags that producers need to think about?
Well, yeah, often the red flags are on the financier side. We also represent financiers.
Okay.
For the producers, when we talk about red flags for them, there can be if the agreements are being presented by the financiers. Often the producers will provide the agreement. When we're doing it, we prefer to. But the financier, they may insist on their providing the agreement. They have their attorney do it. So some of these things I just mentioned, it's either the net profits and the recoupment schedule needs to be very, very clear. So there's no misunderstandings, because most disputes don't arise because one party set out to screw the other party. They arise because there's a misunderstanding, and the misunderstanding comes from vague contracts often. So vague net profits definitions or recoupment schedules. If the investor wants too much control, investors shouldn't have control, because that's what makes them investors. An investor is essentially someone who's going to give money to another person and is ideally going to get their money back through the efforts of that person. In other words, they're passive. That's really what defines an investor. If they're exercising control, then they're not really necessarily an investor anymore, which has implications as to whether or not securities laws apply. And of course, rights and ownership. It's very important that be clear. The producers, typically speaking, maintain all the rights in the project, but that's something that obviously has to be clear. There shouldn't be, though there can be circumstances where it's not left with the production company, but whatever it is, it needs to be very clear. And sometimes the security interest, that has to be clear what the interest is of the financier. Sometimes there's things called copyright mortgages. You were just referring to a house. That's something that the producers, if that's something that's required, they need to understand what that means. There can also be requirements of completion bonds, which means the producers have to go and get a type of insurance that ensures completion of the project. And they have to understand the implications of that if they're agreeing to a completion bond, what that means. So, there's other aspects, there are other things that can be there. They got to be careful, because sometimes it has to be clear about legal fees, for example, because sometimes financiers will require that producers pay their legal fees associated with the financing. So in other words, if a financier rather, is saying he's going to put in $1 million, but he's saying that his legal fees associated with it need to be covered, that can be a lot of money. Mm-hmm. And so producers, if that is a provision, it should be capped and very, very clear. So those are some of the major highlights that producers, at least, should pay attention to in a finance agreement in the event it's provided by the Financiers Council.
I've seen more and more projects going through crowdfunding, whether it's Kickstarter or GoFundMe, any of those. What kind of legal issues can come about with those platforms? How does that's a totally different animal, right?
Yeah, it's a different animal, and it depends on the particular campaign. Each platform has its own rules. So that's one thing that if you're looking to finance on, you have Kickstarter, Indiegogo, GoFundMe, ones like that, and there's many others now. You have to be clear about the model. It's usually expect rewards-based crowdfunding. Backers get perks, not profits. So, that's very different. But filmmakers first have to understand they are legally bound by the platform's term of use. So first things first, really understand the terms of use of that platform. Not fun to read, as I think we've talked about before, that no one really likes to read terms of use, which we get with everything. But these are ones that need to read. And, I was just alluding to, a lot of them are rewards based. That, okay, everyone who puts in $10 gets a T-shirt, everyone puts in $20 gets a T-shirt and a hat, whatever it might be. But some of them now are they are actually share of profits, revenue, or equity, and that crosses into state and federal securities laws, and that is something that filmmakers have to be very, very careful about, because there is both potential civil and criminal liability. It's very serious stuff. So one thing I impart, if no one takes anything else from this, when you're talking about financing, understand that it's very serious stuff because you're involving state and federal securities laws. And even if you don't think you're engaging in fraudulent conduct, you could be accused of it by just not engaging in full disclosure of all the risks. That's something that's very big in these things. So there's a lot of other things, the intellectual property rights and so forth that what is used in these campaigns. So when they're trying to gin up support, this goes back to the discussion we had prior, I think, kind of related to clearances we were talking about in the prior episode, is that they think that it's okay to use music, images, and clips that they don't own in trying to raise money. And there's also restrictions if you're giving people back end participation, profits, things like that. There are different issues that arise about how you can raise money. So it's really important. So I think what you're talking about with these platforms is terms of use and what are you offering? Because if you're offering back end and profit participation and equity, you're implicating state and federal securities laws. And that's when, if you already haven't done so, you really need to talk to an attorney.
Yeah, for sure. For sure. That's interesting. Now, what I always wonder too is like, so, you've got investors, you may have financing, whatever you have. What kind of legal implications are there for the producer and investors if a project runs out of money mid-production or gets shut down for whatever reason? Like, how does that work? I know that's probably a pretty big question.
Well, what you asked is a really important question. What happens if a production runs out of money? That's something that, unfortunately, we've seen, and the legal implications could be very serious for both producers and investors. For the producer, you're very likely cause a breach of contract. And because there's the various contracts you sign a lot of contracts when you're producing a film, not just like we were talking in an earlier episode about clearances. You purchase a script from somebody. You hire actors, you hire crew, and in the case of if you're using SAG actors, then you may have implications with the unions. So there's an issue of breach of contract, union and guild penalties if using SAG or it's WGA or DGA. If for some reason you didn't use a limited liability company or some other entity, you're gonna have personal liability. And it's if you did get a completion bond, which we talked about, now the completion bond guarantor is going to step in and take over the film. So there is enormous implications, and really the lesson is you don't want to be heading into production. You don't want to be spending people's money until you have all the money you need to finish the film. Now, sometimes this is where you'll have gap financing and some other this financing will happen that we were talking about earlier. Maybe they start out with equity financing and maybe they under budgeted and they realize they need more money to finish. Then they have to try and go out and get some additional funds to finish the film. Mm-hmm. So that's another issue, is that you may have to go back to your investors and say, yes, we raised money from you all. Yes, we spent that money. Yes, we spent it on shooting the film, but we need more money. So we either need to get it from you guys or we need to go get it from somebody else. And that somebody else almost certainly is going to require investors to subordinate, and that they'll loan the money. They probably won't be an equity financier. It's possible you could get more equity financiers, but that dilutes the existing financiers.
Right. Yeah.
So it can create a huge mess. This is like the happy version, is that you actually have options. The terrible version is that you just can't find additional money. You can't finish the film, and it's bad for everybody because the investors, they have a film that the only way they get their money back is the film gets distributed, but it's not going to get distributed until it gets done. So how does that happen? So it puts everyone in a terrible position. And, for the investors, like I said, obviously, it can be a loss of an investment, and it's without any ability to recoup.
You brought up a good point before about the LLC. I didn't think about that. Yeah, you don't want to. You want to make sure you're doing everything through a business entity, not yourself, right?
100%. Yeah, it's a lot of people are reluctant to form entities because they don't want the expense of it. And you shouldn't just go ahead and form entities for no reason. But the moment you want to take money from people or you want to contract with people regarding a project, you should form an entity. That's what you're going to do. You're going to have to go ahead and do that and spend the money necessary to form and organize the entity. There should always be great care taken into who maybe you're in that entity with, because when you're in an entity, let's, for example, a limited liability company, and the parties should have an operating agreement which which governs the entity and how it operates. Once you're in that entity with people, it's not that easy to get anybody out, and you're kind of stuck with each other. So even though it's not something you should rush into, it is something you absolutely should be doing if you're raising money. It is an absolute must. You don't want to be raising money in your personal capacity. Not to mention, it doesn't look professional. It looks very shady.
That's a good point too. I didn't think about that angle of it. I was thinking about the protection, but you're totally right. Just like, yeah, just make it out to Kevin.
Yeah, Kevin, just write Kevin a check for $1 million, and I'm totally sure he'll just use it on nothing but the film.
Yeah,
it happens, and it's mind-boggling when it does. But it's crazy things happen in the film business.
Yeah, so, no doubt. People not crossing those T's and dotting those I's, I guess. All right. Well, thanks for listening to today's episode of Cut to Legal. If you're planning to raise money for a film or a digital project and want to make sure your agreements protect you and your investors, visit PacittiLawFirm.com. Be sure to like, subscribe, and leave us a review. If you get a second, we really appreciate it. James, always great talking to you. Thanks so much.
Thanks so much, Kevin. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.